Homeland Security in Israel, Module 1, Terrorism Threats and the Legal Environment, by Nadav Morag. This module, the first in a series of 4 modules on Homeland Security in Israel, will focus on the threat environment and the legal and political realities within which Israeli counterterrorism and Homeland Security policies operate. Over the past 6 years, Israel has faced, on an ongoing basis, 2 categories of terrorist threats: conventional and mega-terror threats. During most of this time period, Israel also had to cope with an increasing rocket threat directed at its border towns and villages near the Gaza Strip. While Israel has never experienced a terrorist attack that came close to approaching the magnitude of the September 11, 2001 attacks in the United States, there have been attempts at carrying out what in Israel are referred to as mega-terrorist attacks. In 2002, there were 2 such attempts. The first involved Palestinian terrorists attempting to recreate the 1993 World Trade Center bombings by driving a van filled with explosives into the underground parking lot of the Azrieli Towers in central Tel Aviv, shown in the photo, which were, at the time, the tallest skyscrapers in Israel and stand atop a large and very popular shopping mall. The terrorists were caught during the security check conducted when they tried to access the underground lot. In Israel, all major public parking lots, particularly those beneath structures, are manned by armed private security guards who inspect the vehicle, both the driver and passenger area and the trunk, and sometimes use mirrors to inspect the undercarriage of the vehicle. It is not uncommon, moreover, for a security guard, during such an inspection, to ask a driver to open a bag or briefcase placed on the passenger seat next to them. Moreover, once the driver has parked his or her vehicle and entered the access routes to the building above, they will usually come face to face with another security guard, often holding a wand, who asks them to open a purse, backpack, or briefcase for an additional inspection and will also wave the wand across their person. The second attempt involved a failed attack against a critical infrastructure target on the northernmost environs of Tel Aviv. The black and white photo shows a fuel storage facility called Pi Glilot. This facility contained gasoline, propane, and other highly flammable liquids and gases. It was well guarded, as the Israeli authorities were well aware, as a number of studies had been conducted regarding the expected impact of an attack or industrial accident at the site, that should there be a massive explosion at the site, approximately 1/3 of the city of Tel Aviv, a city of close to 400,000 inhabitants, would have been wiped out. When this facility was originally built, the inhabited portions of the city were relatively far from the site, but, as with other cities around the world, Tel Aviv grew at a rapid pace, and developers swiftly covered the beach sand dunes near the facility with high-density housing. In May of 2002, terrorists conducted a sophisticated operation in which they planted explosives on the undercarriage of a fuel truck that frequented the facility when the truck was parked at night underneath its owner's apartment building in a city just south of Tel Aviv. When the truck reached the facility the following morning, it passed inspection, and the explosives were set off, using a cell phone as a triggering mechanism once the vehicle had entered the site. Luckily, the ensuing fire was put out before it could threaten the site and result in a huge catastrophe. This case, however, illustrates, notwithstanding the popular image that Israel is always proactive when it comes to dealing with terrorist threats, that Israel, like the United States, is often more reactive than proactive. The authorities in Israel knew that an attack could occur and were aware of the implications of a successful attack. Yet the facility remained and was only emptied of its hazardous materials and closed down in the wake of the failed attack. In addition, terrorist organizations have attempted to conduct very primitive attacks using chemical and biological weapons. The Israeli authorities suspect that on a few occasions, suicide bombers infected with hepatitis were chosen as primitive biological weapons, with the hope being that their blood and tissue, blown far afield by the explosion, would infect their victims. Similarly, in a number of primitive chemical weapons attacks, Suicide belts were laced with rat poison and other chemical agents in the hope that they might be fatally toxic to their victims. None of these primitive WMD attacks, incidentally, had any impact beyond the damage wrought by the conventional explosion of the vest itself. From 2001 on, Palestinian terrorist cells in the Gaza Strip have employed homemade Qassam rockets to attack Israeli towns near the Strip. Only a few people have been killed by these primitive rockets, though they have become increasingly sophisticated and hence increasingly dangerous over time. But they have succeeded in terrorizing border communities and causing serious social and economic problems. Of course, the most common, and therefore in practice the deadliest type of threat, is that of frequent small-scale attacks, many involving suicide terrorist attacks, and these attacks created, between 2000 and 2005, an unprecedented reality for Israeli citizens. This chart illustrates the Israeli death toll from terrorism over the decades of the country's existence. Those injured in terrorist attacks, incidentally, are of an order of 7 to 10 more than the fatalities. These figures probably belie the conventional thinking regarding the impact of terrorism on Israel over the years, and they underscore the fact that terrorism is far less violent than war, or, for that matter, takes far fewer lives than disease or even traffic accidents which, in Israel, are a far greater scourge than terrorism. At any rate, the number of fatalities at the hands of terrorists generally fluctuated between under 400 to under 200 per decade. With the establishment of Palestinian self-rule over Palestinian urban areas during the Oslo peace process, the number of Israeli fatalities to terrorism passed the 400 mark, as terrorist organizations were able to organize and plan operations, largely out of reach of Israeli security forces, within autonomous Palestinian enclaves. The Palestinian leadership's attitude toward terrorism and willingness to crack down on terrorists was largely a function of the degree of pressure to which they were subject by Israel and the international community. Generally speaking, the leadership of the Palestinian Authority, the Palestinian governing body created by the Oslo Accords, was loath to view terrorists as terrorists, preferring to see them instead as patriots, albeit perhaps misguided ones. Moreover, in the wake of successful terrorists' attacks, Palestinian leaders were able to attempt to reinforce their consistent message that Israeli occupation was producing a violent Palestinian reaction, and that ending the occupation, in other words, making further territorial concessions, would end terrorism. Consequently, terrorism directed against Israel was not devoid of its merits in terms of achieving Palestinian interests, or so it was apparently thought at the time. However, the increasing violence, along with Israeli measures, such as settlement expansion, that were objectionable to the Palestinians, eroded attempts to create the mutual trust and cooperation that would be necessary to bring about a final peace settlement between the parties. Ultimately, Palestinian leader Yasser Arafat rebuffed attempts by President Bill Clinton and Israeli Prime Minister Ehud Barak to achieve an agreement on a final settlement at Camp David in the summer of 2000 and at Taba in January 2001, viewing the proposals as unacceptable, as they did not give Palestinians sovereignty over the entire West Bank and East Jerusalem. They appeared to allow total Palestinian sovereignty over the Gaza Strip, and did not recognize the so-called Palestinian right of return. With the onset of what the Palestinians refer to as the Al-Aqsa Intifada in September 2000, the number of terrorist attacks and the death and injury rate in Israel exploded. The Palestinians emptied their jails of suspected and convicted terrorists and allowed members of their security forces to actively engage in terrorist operations. This, in addition to carrying out a low-level guerrilla war against the Israeli military in the West Bank and Gaza Strip. Israel's initial reluctance to operate inside Palestinian autonomous areas, both for fear of international condemnation at the violation of Palestinian territory, and also because Israel did not relish the thought of having to reoccupy Palestinian cities and resume responsibility for the Palestinian population's needs, meant that terrorists could freely use those areas to organize attacks. Eventually, Israel's strategic approach to the conflict changed, and it decided to reoccupy most of the Palestinian cities on the West Bank in what was, at the time, the largest military operation conducted since the 1982 Lebanon War. This military operation, known as Operation Defensive Shield and carried out from late March to mid-April of 2002, signified the beginnings of a more effective Israeli counterterrorism strategy which produced rapid results in terms of lowering the Israeli death rate. Though not surprisingly, in view of the fact that military operations were conducted almost exclusively in urban areas, the death rate among innocent Palestinian non-combatants rose precipitously. More will be said in the next module regarding Israel's counterterrorism strategies and their results. This graph shows a representative distribution of types of terrorist attacks experienced by Israel during 2004. As you can see, the majority of attacks were carried out by suicide bombers, whose attacks were overwhelmingly more destructive than those using hidden bombs, firearms, or other measures. The Palestinians referred to their suicide bombers as smart bombs, designed to create a level playing field with Israel, which was in possession of precision-guided munitions, aka smart bombs. Only the Palestinian smart bombs were smarter because they could change the target of the mission up to the last moment. One example which proves the Palestinian point has to do with a suicide terrorist attack on March 4, 1996, outside a busy mall in downtown Tel Aviv, called Dizengoff Center, for which both Hamas and Islamic Jihad claimed responsibility. The common modus operandi for suicide attacks involved one or two handlers from the terrorist organization physically taking the suicide bomber to within several hundred meters of his target, both to ensure that he is able to easily find the target and to ensure that he does not develop cold feet at the last moment and decide to unilaterally cancel the operation. In this case, investigators discovered later that the bomber was supposed to gain access to the shopping mall and subsequently blow himself up inside it, thus increasing the blast pressures and heat effect that would be produced in an enclosed environment. The terrorist, however, spotted private security guards checking bags at the entrance to the mall and made a last-minute decision to blow himself up outside the mall. As it was a Friday and thus the middle of the weekend, the Israeli weekend is Friday and Saturday, the street outside the mall was full of people. The terrorist waited at a crosswalk until the light changed and then blew himself up when pedestrians coming in opposite directions met at the center of the crosswalk. This is a prime example of the flexibility and destructiveness of a human smart bomb. As far as targets are concerned, as can be seen from this chart, the focus was primarily on public places, not including restaurants and shops, and public transportation. Most of the attacks against military assets occurred at checkpoints leading from the West Bank or Gaza Strip into Israel, or against military personnel on patrol in the West Bank and Gaza, which could arguably be classified as an act of guerrilla warfare rather than terrorism. Terrorist organizations frequently took advantage of the fact that thousands of Palestinians entered Israel each day to work and tried to infiltrate suicide bombers into their ranks. In other cases, the checkpoint represented the most readily available Israeli target, as many of them were placed just outside Palestinian population centers. After briefly looking at the threat environment, we can now turn to the legal environment within which Israel's counterterrorism policies operate. Israel is a liberal democracy functioning under the rule of law that affords legal rights and protections to its inhabitants. Israel, unlike the United States, however, is a parliamentary democracy where there is no true separation between the legislative and executive branches. A cabinet must enjoy a majority in parliament in order to be able to run the executive branch. Incidentally, parliamentary democracy is the most common form of democratic governance in the world, and presidential democracies, such as that of the United States, are comparatively rare. Executive power resides in the cabinet in parliamentary systems and in the president in the USA. The dominance of the cabinet over the parliament, where it has a majority, also means that there are fewer restrictions on policy planning and implementation in countries with these systems, such as Britain and Israel. Israel differs from Britain and most other parliamentary democracies, however, in the fact that no single party ever achieves a majority in the Israeli parliament, called the Knesset, and consequently cabinets are formed by coalitions of parties, also known as coalition government. This sometimes makes Israeli cabinets somewhat chaotic, and Israeli prime ministers often have to act more as consensus builders than leaders in order to keep together coalitions of parties with different agendas and ideologies. One of the repercussions of this need to maintain coalitions is that long-range planning is highly difficult, as Israeli cabinets do not always last for their entire 4-year term, and the prime minister must be careful not to be seen as supporting positions that might irrevocably alienate his or her coalition partners in the cabinet, also known as the government, causing them to leave the government and vote against it in the Knesset, which may result in the calling of early elections if the government no longer enjoys majority support in parliament. Israel also differs from the United States in that it is a centralized state, not a federal one, with no state governments, no county governments, and very limited autonomy for municipalities or village councils. Law enforcement, for example, is centralized, with one national police force acting as the sole law enforcement body in the country, and mayors or heads of village councils having no formal control over the police. Israel, like Great Britain, also lacks a formal constitution, and thus relies primarily on its court system, particularly the Supreme Court, to safeguard civil liberties. Israel has what is arguably the most powerful Supreme Court in the world. The court not only acts as an appellate court for all court cases in Israel, but also as a high court of justice, thus ruling in matters regarding the legality of decisions made by executive and legislative authorities. In its capacity as a high court of justice, the Supreme Court has sometimes overturned governmental decisions, and in all cases where people have been affected by official decisions, including Palestinians in the West Bank and Gaza, those people can petition the Supreme Court, which is able, if it so chooses, to change official policy. The court also has the right to review legislation passed by Parliament and, in December 2006, overturned parts of a law which removed any liability of the state for the deaths of Palestinian civilians or damage to Palestinian property as a result of Israeli military action. In the United States, of course, the Supreme Court interprets the Constitution and functions primarily as an appellate court. The Israeli military, the IDF, or Israel Defense Force, as in other democracies, is subordinate to the political leadership. Nevertheless, the military's opinion carries great weight among the decision-makers, some of whom are themselves ex-generals. The IDF's planning branch prepares strategic policy recommendations for the Prime Minister, not limited exclusively to military matters, and the IDF's military intelligence branch provides the cabinet with the national intelligence estimate, therefore, at least nominally, acting as the country's leading intelligence agency. In the United States, the military is not nearly as influential and must compete with powerful civilian agencies such as the National Security Council, the CIA, the State Department, and the Department of Homeland Security. Counterterrorism strategy may be thought of as a continuum. On one end, the policy is based on a law enforcement approach, whereas on the other, it is based on a war-fighting approach. Democratic countries facing serious terrorist threats must decide, based on political traditions, institutional makeup, or other factors, which approach to emphasize. The war-fighting approach is characterized by attempts to neutralize the terrorist organization via capture or physical elimination of its members, and across-the-board intelligence-gathering efforts designed to ascertain the organization's capabilities and intentions. The law enforcement approach is focused on the gathering of evidence and legal prosecution of individuals, and must be aware and respectful of legal conventions, civil liberties, and the rights of suspects, who are, in this context, suspects that are innocent until proven guilty, rather than enemy combatants that need to be neutralized. In terms of legislation, Israel has 3 categories of powerful legislative tools with which to conduct its counterterrorism efforts. The first 2 of these legislative categories focus on the law enforcement end of the continuum, via enabling the gathering of evidence and prosecution of terrorism suspects, and the third also reflects the war-fighting end of the continuum through granting special powers to the authorities. The first piece of legislation, the Prevention of Terrorism Ordinance, dates from 1948, the year of Israel's inception, and allows for the prosecution of anyone suspected of membership in a terrorist organization, publishing propaganda for the organization, managing the organization, fundraising, or transferring funds for the organization. The ordinance can only be in effect so long as Israel remains within a legal state of emergency. The second piece of legislation, the Penal Law, updated in 1996, allows for prosecution of terrorism suspects under ordinary criminal procedures. Some auxiliary pieces of criminal legislation, such as the Prohibition of Money Laundering Law from 2000, the Combating Criminal Organizations Law from 2003, or the 2001 amendment to the Extradition Law, may also be useful for the conduct of standard criminal prosecutions against terrorism suspects, or for facilitating extradition of suspected terrorists to other countries. The penal law, in addition to allowing prosecution for ordinary crimes, allows for prosecution of suspects trying to subvert the political order in Israel through attempts to overthrow the lawful government by force or employment of sabotage against state property. The penal law remains enforced regardless of whether Israel is in a state of emergency or not. Finally, emergency legislation gives the security forces broad powers to disrupt the activities of terrorist organizations. Israel, in fact, has been in a legal state of emergency since its inception in May 1948. The state of emergency was first declared by British authorities in Mandatory Palestine in 1937 as a result of the Arab uprising, was maintained during World War II, and continued with the termination of the Mandate. Upon the establishment of the State of Israel, the Provisional Council of State proclaimed a state of emergency, and the country has been under this stage of emergency, which is renewed annually ever since. There are three separate channels of emergency legislation. 1. The Defense Regulations State of Emergency, a 1945 British Legislative Act, allows for the imposition of martial law in Israel and the occupied territories. Military commanders have the power to demolish houses, impose curfews, arrest, search, and detain without judicial authorization, censor the press, prohibit meetings, open and confiscate mail, etc. In theory, the local military commander can use these powers, but in practice no significant measures have been taken, especially not within Israel proper, without the authorization of elected political authorities, in other words, the cabinet or the minister of defense. 2. Section 9 of the Law and Administrative Ordinance, 1948, authorizes the government or a minister to promulgate emergency regulations, executive legislation, that can revoke, suspend, or alter the enactment of Knesset legislation during a state of emergency. The Knesset must declare the state of emergency. These can remain in force only for a maximum of 3 months. However, much of the permanent emergency legislation passed by the Knesset is based on Section 9 legislation, which was extended indefinitely by the Knesset. And 3. The Knesset can pass emergency legislation. Under the defense regulations and other emergency legislation, Israeli law enforcement bodies are given broad powers to deal with terrorism. Within Israel, the only body authorized to arrest suspects is the Israeli police. In the Gaza Strip, which Israel withdrew from in the summer of 2005, but which its forces periodically enter, and in the West Bank, large parts of which are under Israeli military occupation, the primary agency that arrests suspects is the IDF, though the police have the authority to arrest individuals in the West Bank as well. Emergency legislation allows the IDF to detain Palestinian suspects for 12 days before being brought before a military magistrate. Military law applies in the West Bank and with respect to Israeli operations in Gaza, but not in Israel itself, and 4 days before allowing the suspect access to legal representation. The IDF had initially issued an order in April 2002 authorizing its forces to detain suspects for 18 days prior to judicial review and access to legal representation. But public pressure and concern that the Supreme Court might intervene and force the military's hand led the IDF to modify its order. Within Israel itself, suspects can be detained under emergency legislation for no longer than 48 hours before being brought before a magistrate. Emergency legislation also allows suspects to be held for fixed periods of time without going through a normal conviction process. This is known as administrative detention and resembles the American practice by which the United States holds some categories of enemy combatants at Guantanamo Bay. Within Israel, only the Minister of Defense has the authority to issue administrative detention orders for up to 6 months, with the ability to renew these orders. In the West Bank, or in IDF operations within the Gaza Strip, the local military commander has the power to issue an administrative detention order for up to 6 months, which also can be renewed. All administrative detention orders are subject to review by the Supreme Court, should the detainee's lawyers choose to appeal these orders. The defense lawyers, incidentally, do not have the right to access to evidence gathered by the authorities against their clients, if disclosure of that evidence may compromise sensitive intelligence sources and methods. Administrative detention serves as a quick and efficient alternative to criminal proceedings because it does not require the investment in time necessary to gather sufficient evidence to charge an individual, and because it allows the authorities to protect intelligence sources and methods. Emergency legislation also allows for closures, ringing an area with checkpoints and limiting access to or from that location, curfews, confiscation of mail, closing of newspapers or publishing houses, the banning of public gatherings, etc. It should be noted that these powers are rarely used within Israel proper, but are much more commonplace in the West Bank and in Gaza when it was under Israeli occupation between 1967 and 2005. In most cases, people held under administrative detention are eventually either released or tried, either by a civilian court in the case of Israeli citizens and some Palestinians, or by a military tribunal in the case of most of the Palestinians. In general, suspects arrested by the police may be held for 96 hours before being arraigned. This law was temporarily amended, pending further legislation, in June 2006. Prior to that, suspects could be held for only 48 hours, and this often did not give the police enough time to gather evidence for the arraignment, with the result being the frequent release of suspects who should have remained in custody. Historically, the interrogation of terrorism suspects has often involved some degree of physical force. The Israeli approach traditionally made protecting the Israeli population from terrorist attack through acquisition of intelligence from detainees a significantly higher value than safeguarding the rights of those detainees. In 1987, however, following widespread complaints of torture, a judicial commission created a set of recommendations, not made public, governing the interrogation process. It was found, however, that in a number of subsequent governmental studies, these too were not made public, that Israel's Domestic Intelligence Service, the Israel Security Agency, ISA, also known as Shabak or Shin Bet, was continuing to violate some of those guidelines. In 1999, the Supreme Court ruled that the ISA could not use physical torture, and the agency claims that it now employs exclusively psychological methods, though this assertion is disputed by human rights groups who claim that detainees are still subject to being put into uncomfortable positions for long periods of time, being held in filthy conditions, being violently shaken, being exposed to blasts of cold air, being slapped, and being verbally abused and threatened. Terrorism is, of course, an act of mass communication more so than it is an act of violence. Consequently, control of the tools of communication, or at least the manner in which information is transmitted, is clearly a matter that governments must explore. The primary question for a democracy, however, is whether it can and should practice censorship as a means to blunt the terrorist's ability to achieve his or her true goal, the creation of widespread panic that adversely affects society and the economy and forces the political leadership to change its policies. With respect to matters of censorship in Israel, it is often said that the typical Israeli answer to a yes or no question is yes and no, and this Israeli answer is appropriate for the question of censorship, as there is a huge gap between the legal framework that limits freedom of the press and the real-world practice which allows it. Censorship policy stretching from the establishment of Israel in 1948 to well into the 1990s held that full freedom of expression on political matters was allowed, as long as state secrets were not disclosed. But at the same time, there was no grasp of the concept that citizens actually have a right to know. In fact, to the present, there is no law in Israel which guarantees the citizen access to governmental information. Censorship in Israel traditionally took a number of forms. Firstly, all newspapers and electronic broadcasters could operate only with a license granted by the Ministry of the Interior, and that body had the authority to temporarily or permanently revoke these licenses. Secondly, the IDF military censor had the authority to block the publication of information that was deemed dangerous to national security, and the print and electronic media were required to submit all stories of a national security nature to the censor for approval prior to their publication or broadcasting. This rule also applied, at least in theory, to the international media based in Israel, who could lose the press accreditation granted to them by the government press office. Thirdly, criminal proceedings could be undertaken against anyone with access to classified information who subsequently disclosed this information to unauthorized persons. Historically, the press also agreed to accept two types of voluntary restrictions. Firstly, the chief editors of the print and electronic media agreed to impose voluntary censorship in certain areas so as not to harm national security and, in exchange, were made privy to sensitive information and received special briefings from government officials in exchange for their willingness not to publish or broadcast certain kinds of information or to delay the publication or broadcast of this information. This informal arrangement was known as the Editors' Committee. Secondly, the IDF established a special accreditation system for what were termed military reporters. These representatives of the media sometimes acted as embedded media, but more commonly were given direct lines of communication to senior commanders and were made privy to information not shared with other members of the press. They were also required, in times of war, to clear their reports with the IDF spokesperson's office before publication or broadcast. As the military reporter designation is one granted by the IDF, it can also be revoked, and this helps ensure that these journalists will not be overly critical of the military or too zealous in exposing its weaknesses. Though in practice, military reporters have, at times, been highly critical of senior commanders and others in the IDF, or given voice to internecine political battles within the military by acting as unofficial spokespersons for one side or the other. While the international media, which is very heavily represented in Israel, is technically subject to the military censor, the censor's ability to control foreign reporters is highly limited. As noted earlier, official accreditation can be revoked, but this is always subject to foreign policy considerations, and foreign governments often intervene, almost always with successful results, when their journalists run afoul of Israel's government press office. Moreover, the media revolution, which has resulted in a vast proliferation of media outlets, makes censorship highly impractical, and this, coupled with the frequent use of the media by politicians and bureaucrats for leaking information in order to advance political agendas, and the growing influence of global democratic norms, mean that the seemingly harsh censorship laws are, today, rarely enforced. It should be noted that censorship in time of war is not unique to Israel and is practiced by other democracies, though censorship in those cases is usually carried out by civilian authorities and not by the military. Incidentally, when the institution of the military censor got its start, there were no clear guidelines on what should be censored. When Avner Baron, who was chief censor for 26 years, first got his post, he asked Chief of Staff Yigal Yadin what the term harm to state security meant. Yadin, with an irked expression on his face, replied impatiently, "There is the censor whom you are supposed to replace. Talk to him." Baron then talked to the outgoing censor, Gershon Dror. and asked him what state security meant. Dror replied, quote, "It is impossible to define it. After you will have been in this position for some time, you will know what is harmful to state security and what is not." Close quote. This is reminiscent of Justice Potter Stewart's claim with respect to pornography, that he could not intelligibly define it, but that he knew it when he saw it.